Welcome back to the Deep Dive. Today, we are exploring a moment in American history that really proves the most consequential turning points don't always happen out in the open.
Not at all.
We aren't looking at a constitutional convention or a battle or some revolutionary act of Congress.
No.
We are focusing on one single vote cast in total secret that saved the independence of the Supreme Court, and in doing so, just fundamentally redefined the relationship between the government and the economy.
It's a fantastic story, and I think the best way to picture this whole episode is to think of history as a dam.
Okay, a dam.
Yeah, the huge volume of water rising behind it, that's the years, decades even, of political tension, of economic grievances, of sheer public demand for the government to do something.
And by 1937, the water is at the very top.
It's at the top. The reservoir is full to bursting, and it's being pressurized by the greatest economic catastrophe the nation had ever seen, the Great Depression.
And the force pushing that water, the source of all that pressure, has to be the immense political mandate of President Franklin D. Roosevelt.
Oh, absolutely.
Yeah.
He had just won a landslide re-election on November 3rd, 1936. And you have to understand, that wasn't just a political win.
No, it was a command.
It was a public command to enact the New Deal, to use the full power of the federal government to stabilize a society that was just completely collapsing.
So that's the water, the pressure.
That's the water. But standing as this unyielding wall, this massive concrete obstruction, was the United States Supreme Court.
Right.
Specifically, a narrow but really powerful conservative block of justices who were consistently striking down every major piece of New Deal legislation.
Using legal ideas from another century.
From another world, almost. So this was no longer just an economic crisis. It had become a full-blown constitutional standoff.
Right.
Which branch of government truly had the final say?
And the crack. The pivotal hidden moment that decides whether the whole thing shatters or holds.
That's the amazing part. It wasn't a presidential fireside chat or a dramatic debate in Congress.
It was what?
It was the silent, internal decision of a single man, Associate Justice Owen J. Roberts, made in a private conference room in Washington, D.C. in December of 1936.
One man's mind changing.
That decision, that one shift, is what history now calls the switch in time that saved nine.
So our mission for this deep dive is to get right into that single pivot. We'll start by setting up the immense political and legal pressure that was building.
Then we'll pinpoint that quiet, almost invisible moment of Roberts' reversal.
And finally, we'll explore the massive, transforming flood of consequences that followed. I mean, the consequences that really define the modern American regulatory state.
And we are hunting for that key insight, that the crucial decision to save the court happened before the public crisis ever really exploded.
Okay, let's unpack this. If FDR and the New Deal were the rising water, we have to start with the wall. What was the legal philosophy of this group of justices standing against him?
Absolutely. Because to Roosevelt's supporters, and frankly to most of the country, the court felt completely detached from the reality of breadlines and mass unemployment.
It was an ivory tower.
A fortress. And the resistance was personified by this conservative bloc, known to the press and the public as the Four Horsemen.
The Four Horsemen. That's Justices James Clark McReynolds, Willis Van Devanter, George Sutherland, and Pierce Butler.
Right. And they were a unified force. An intellectual bloc.
A truly immovable object. And it wasn't just that they were personally conservative. They held to a very specific, and by the 1930s, you could say a deeply outdated legal philosophy.
That's the perfect way to put it. That philosophy was their weapon against any kind of government intervention.
So what was that core theory?
It was all rooted in the doctrine of liberty of contract. Sometimes you'll hear legal historians call it sort of the freedom of the marketplace.
Okay.
This philosophy interpreted the Due Process Clause of the 14th Amendment, which says no state shall deprive any person of life, liberty, or property without due process of law. They took that and interpreted it as an absolute constitutional protection for economic deals.
So wait, liberty in this context didn't mean, freedom of speech or personal freedom. It meant the freedom of a boss and a worker to agree to any wage they wanted, no matter how low.
Precisely. They saw the Constitution as guaranteeing an almost absolute freedom for that negotiation, regardless of these massive, obvious disparities in bargaining power.
I mean, the bargaining power between a giant steel company and one unemployed worker during the Depression.
There is none. But to them, any attempt by the government, state, or federal to impose a minimum wage, to limit working hours, to ban child labor, that was seen as an unconstitutional violation of that sacred economic liberty.
And this wasn't a new idea in 1935. This was the legacy of what's called the Lochner era.
Right. It goes way back to 1905, Lochner v. New York, where the court struck down a state law limiting bakers' working hours to 60 per week.
60 hours a week was seen as too much government interference.
Exactly. And that set off a 40-year precedent of, you could call it, judicial activism on behalf of business interests.
That's the critical context. For 4 decades, the court had been using this interpretation of the 14th Amendment to veto economic laws. But in the 1930s, the stakes were, well, they were existential.
Totally existential. The Four Horsemen were now using this old doctrine to dismantle the New Deal piece by piece, driving that constitutional pressure to a point it had never been before.
Can you just remind us of what kind of programs they were striking down? Because these weren't small regulations. These were the absolute pillars of FDR's recovery plan.
They were. I mean, think about 2 of the biggest rulings. In May 1935, in a case called A.L.A. Schechter Poultry Corp v. United States.
The sick chicken case?
The famous sick chicken case, yes. The court unanimously struck down the National Industrial Recovery Act, the NIRA, which was the cornerstone of early New Deal industrial planning.
Unanimously.
Unanimously. They said it was an unconstitutional delegation of power. Then, less than a year later, January 1936, the court invalidates the Agricultural Adjustment Act, the AAA, in United States v. Butler.
And that was the program meant to save the entire farm economy.
It was meant to stabilize prices by paying farmers to reduce their output. Gone.
So the court wasn't just, tweaking the programs at the edges. They were declaring that the core mechanisms FDR was using to fight the Depression were entirely unconstitutional.
That was the message. They were effectively saying, your plan to save the country is illegal. It was a direct confrontation.
So the Four Horsemen were a guaranteed 4 votes against everything the administration was trying to do. But the Supreme Court has 9 justices.
Right, which meant the crisis hinged on the other 5.
And that's where you find this incredibly fragile balance. The court was really divided 4-3, with the Four Horsemen on one side opposing the liberal bloc.
The 3 Musketeers, as they were called.
Right. Justices Lou Brandeis, Benjamin Cardozo, and Harlan Fistone. And these 3 were consistently arguing for deference to the legislature, especially in a crisis.
Which meant that the fate of every New Deal program, and you could argue the fate of the nation's recovery and the future of American government, it all rested on the final 2 men in the middle.
And those 2 deciders were Chief Justice Charles Evans Hughes, who was known as a brilliant and politically savvy leader,
and Associate Justice Owen Roberts, who had this reputation for being the most inscrutable man on the bench. He was often seen as this objective, legalistic swing vote.
And here's why the conservatives felt so completely secure heading into 1936 and 1937.
Mm-hmm.
Roberts had not been reliably voting with the liberals.
Not at all. In fact, he had just recently joined the conservatives on the exact constitutional issue that was about to be decided again.
Which brings us to the crucial precedent, a case called Moorhead v. New York ex rel. Tipaldo.
This is the critical background detail, because it's what makes Roberts' later decision so absolutely astonishing.
So what was Moorhead about?
Moorhead was decided on June 1st, 1936. The court struck down a New York state law that established a minimum wage for women.
A state law.
State law. And the vote, which killed that law, was 5-4.
And let me guess, the 5th vote, the man who joined the Four Horsemen to strike down minimum wage legislation,
was Justice Owen Roberts. Exactly. This sets up an immense legal hurdle. In the judicial world, the principle of stare decisis, which is just the idea that you follow established precedent, is absolutely foundational.
You don't just flip-flop.
You do not. A justice reversing his own position on an identical legal question, especially on the constitutionality of minimum wage, in less than a year. It's almost unheard of. It suggests, a collapse of stability or admitting you made a profound error.
So the White House, the legal community, they had every reason to believe Roberts' mind was made up. The fight was over.
The fight was over. And it seemed like government regulation was dead.
So the New Deal is facing not just a policy defeat, but a precedent from the swing justice himself. But the vehicle that finally forces this constitutional crisis to a head, it wasn't a massive federal law like the NIRA.
No, it was, surprisingly, an incredibly small human case.
It was about the paycheck of one woman.
The paycheck of Elsie Parrish, a chambermaid in Wenatchee, Washington. Her case, West Coast Hotel Go v. Parrish, became the legal test that forced the showdown. And it was all about $216.06 in back wages.
$216. It's not a lot today, but during the Depression, for a working woman, that's a fortune.
A fortune. And she was owed that money under a Washington state minimum wage law for women and minors. But the West Coast Hotel refused to pay, and they cited that liberty of contract doctrine.
The same idea from Lochner and Moorhead.
Exactly the same idea.
Mm.
And the human element here is so important. Elsie Parish represented the most vulnerable population. The state of Washington argued that its police power, its ability to protect the health, safety, and welfare of its citizens justified the minimum wage, especially for women who are often subject to these incredibly exploitative wages.
So the question before the Supreme Court was stark. Did the Constitution's protection of economic liberty mean that the government was absolutely powerless to prevent starvation wages?
That was it. The stakes were impossibly high. Yet the case itself focused on a few $100s for one employee. The stage was set for a guaranteed conservative victory.
Which would confirm the death of government regulation.
And that brings us to part two, the invisible Cracker Roberts' quiet reversal.
All right, so arguments for West Coast Hotel concluded in December 1936. And based on Roberts' vote in Moorhead just 6 months earlier, everyone, the president, the press, the legal community, everyone expected a crushing 5-4 defeat for the state of Washington.
The expectation of defeat wasn't just, rational. It was the consensus. If Roberts had voted as everyone expected him to, the conservatives would have definitively won the war against economic regulation at the state level.
And by extension, the federal level.
Absolutely. The New Deal's entire structure would have been doomed. And that defeat would have provided President Roosevelt with the undeniable popular justification he needed for a radical, unprecedented political response.
Let's just emphasize the fragility here, the historical knife's edge. Had Roberts simply followed his own immediate precedent from Moorhead,
The whole constitutional framework would have been placed under impossible stress. The public crisis would have exploded overnight.
that near miss, that counterfactual, is so critical to understanding this. The court packing plan, which we know was already being thought about, would have had massive political momentum.
It would have likely passed, and the structure of the judiciary would have been changed forever.
But something else happened first, something that happened in total secrecy. We're talking about the Supreme Court's private conference in December of 1936.
And the secrecy of that room, you just can't overstate it. When the 9 justices meet to discuss cases and vote, no public record is kept. No clerks are present, no one.
It's designed to allow for frank debate.
Right. But it means that some of the most crucial turning points in American history happened with no paper trail. The decision to uphold or strike down a law, it happens in this quiet, enclosed space.
So let's reconstruct that scene based on the historical memos we have now. Chief Justice Hughes polls the justices, starting with the most junior member. The votes stack up just as you'd expect.
The 3 liberals, Brandeis, Cardozo, Stone, they vote to uphold the Washington law.
The 4 conservatives, the 4 horsemen, they vote to strike it down.
And the tally is 4-4.
Everything stops.
The room falls silent, waiting for Owen Roberts. The man who was responsible for the 5-4 split just 6 months earlier on the exact same legal question. Every constitutional anchor is resting on this one quiet breath.
And in that room, the wall cracks. Justice Roberts casts his vote.
He sides with the liberals. He votes to uphold the Washington state minimum wage law. The vote flips to 5-4.
Wow.
A jurisprudential earthquake occurs with a whisper in a private room. The constitutional crisis is internally resolved. The New Deal is saved. Judicial independence is saved.
And nobody outside of those 9 men knew it had happened.
Absolutely no one. The decision to retreat from the Lochner era had been made in secret.
And this is where the historical narrative gets so fascinating, because the popular story, the one everyone knows, is that Roberts panicked and switched his vote in March of 37 as a direct response to Roosevelt's public threat.
Right, that he caved to the pressure.
But the sources, the actual evidence, tells a different, much more nuanced story.
It absolutely does. The definitive historical evidence confirms that the vote was cast in December 1936. We know this mainly from 2 sources. First, Chief Justice Charles Evans Hughes' own private notes, which he wrote between 1941 and 1945.
And in those notes,
He explicitly corroborates that the decision to uphold the minimum wage law was made in December.
and even more compellingly, Roberts himself left a record.
Yes. Roberts wrote a private memorandum, which he gave to the legal scholar Felix Frankfurter, and it was published after his death in 1955.
What did it say?
In that document, Roberts explicitly refutes the political pressure narrative. He says his decision was based purely on legal reasoning and constitutional evolution, and he affirms that his vote was cast before the court-packing plan was ever publicly announced.
So this shifts the story from one of political surrender to one of, what, deep legal conviction, or maybe institutional foresight.
I think that's right. He saw the crisis coming. Legal scholars who study this, people like Barry Cushman, they argue that the groundwork for Roberts' switch was already being laid in earlier cases.
He was evolving.
He was evolving. He was increasingly struggling with the economic and social reality that the liberty of contract philosophy was just failing to address the Depression. His switch was an evolution, not an abrupt, fearful reversal. He was acknowledging that for the court to survive, it had to recognize reality.
But, okay, if the vote was cast and the crisis was resolved internally in December of 36, why didn't the world know? Why did this secret just linger, allowing the greatest constitutional crisis of the 20th century to brew publicly?
This is the profound, dramatic irony of the whole story. The announcement of the decision was delayed for months, all the way until March 29, 1937.
Why?
Due to a highly unfortunate circumstance. The illness of Justice Harlan Fiskstone, a member of the new 5-4 majority, and this delay created this massive, pregnant vacuum of information.
And into that vacuum steps President Roosevelt with his blind gambit.
Blind is the perfect word for it. Because the court's decision was a secret, FDR assumed the worst. That another devastating 5-4 defeat was coming in the West Coast hotel case. He saw the court as an intractable, permanent enemy that had to be neutralized for the sake of the country's survival.
He was under an unbelievable strain. His signature laws had been gutted. He felt he had no choice but to do something dramatic.
So on February 5, 1937, less than 2 months after Roberts had already cast his deciding vote in secret, Roosevelt shocks the nation. He unveils the Judicial Procedures Reform Bill of 1937.
Instantly and forever known as the court-packing plan.
Exactly.
Ah.
It was an audacious, aggressive political move.
Yeah.
It was cloaked in this rhetoric of judicial efficiency, claiming the elderly justices needed help to handle the backlog of cases.
But the mechanism was pure power politics. Let's just detail the specifics, because it was breathtakingly bold.
It was. For every Supreme Court justice over the age of 70 who did not retire, the president could appoint one additional justice.
And at the time, 6 of the 9 justices were over 70.
Which means, had the bill passed, FDR could have instantly appointed 6 new members, expanding the court from 9 to 15. He would have had a massive, guaranteed majority.
He used his March 9th fireside chat to sell the plan to the American people, framing it as a defense of the Constitution itself.
He said, "We must find a way to take an appeal from the Supreme Court to the Constitution itself." He positioned himself as defending democracy from this rogue, unelected body.
The irony is just, it's profound. He was launching a full-scale constitutional war, risking all his political capital, risking the sanctity of checks and balances.
To change a vote that had already changed months prior. The siege was completely unnecessary. But no one knew.
And the political reaction was immediate, right, even before the Parrish decision was announced.
Oh, it was severe. And this is a key detail that gets lost. He faced massive pushback, not just from Republicans, but from his own party.
Democrats were against it.
Many powerful conservative and moderate Democrats, including his own Vice President, John Nance Garner, saw the plan as a dangerous overreach, a threat to the separation of powers.
They saw the danger of the precedent it would set.
Exactly. So the debate was fierce, deeply dividing the very party that had just given him this huge mandate.
So the tension is just unbearable. The president is fighting this bruising public war against the court, totally unaware that the legal foundation of the court's resistance has already silently crumbled.
And this brings us to part 3, the flood, the constitutional revolution. The day of revelation finally arrived on March 29, 1937.
Imagine the scene in the Supreme Court chamber that morning. The atmosphere must have been electric. Everyone in Washington was waiting for the verdict on West Coast Hotel Covey Parrish.
And they were all expecting the 5-4 vote, confirming the Moorhead precedent.
Which would have given FDR the final, crushing justification he needed for his court-packing scheme.
But when Chief Justice Hughes began reading the majority opinion, the ground shifted under everyone's feet instantly. The court announced it was upholding the Washington minimum wage law. The old precedent was being overruled.
The vote was 5-4, and the single most important name in that opinion was the 5th justice,
Owen J. Roberts.
The switch was made public.
And the political world immediately understood the implication. This one decision, in an instant, irrevocably gutted the central argument for the court-packing plan.
The entire premise of FDR's bill, that the court was an intractable, permanent roadblock, it just vanished overnight.
The court had proven on the most sensitive economic issue that it was capable of institutional evolution. The crisis, which had been constitutional, immediately became purely political. FDR's plan now looked less like a necessary defense of democracy.
And more like an ill-timed, heavy-handed power grab.
The immediate political effect was profound. But the long-term legal consequences of the West Coast hotel decision were truly tectonic. This wasn't just about Elsie Parrish getting paid her back wages.
No, this was a formal public surrender in the decades-long war over freedom of contract.
This is the definitive end of the Lochner era, that 40-year period where the court acted like a super legislature, second-guessing the economic policies of elected bodies.
So how did the majority opinion justify such a dramatic reversal of its own precedent from just 6 months earlier?
Chief Justice Hughes, writing for the majority, he made the philosophical break explicit. He essentially redefined liberty under the 14th Amendment. He wrote, and this is a quote that fundamentally changed American law, "The Constitution does not speak of freedom of contract.
Wow.
The liberty safeguarded is liberty in a social organization which requires the protection of law against the evils which menace the health, safety, morals, and welfare of the people."
That is monumental. It's the Supreme Court officially conceding that economic liberty is not absolute. They're acknowledging the reality of unequal bargaining power.
And agreeing that the government, the elected representatives, could intervene for the public good. The court was shifting from activism on economic policy to judicial deference.
And that deference opened the floodgates.
For the entire modern regulatory state. The decision meant that from now on, economic legislation would largely be presumed constitutional, overturning decades of rigid judicial skepticism.
And to prove this wasn't just a one-off, isolated attempt to defuse the president, the court confirmed its new direction just 2 weeks later.
That's right, in a case with even wider implications for federal power. NLRB v. Jones and Laughlin Steel Corp. Decided April 12, 1937.
And the vote?
5-4 again, with Justice Roberts again joining the majority. They upheld the constitutionality of the National Labor Relations Act, the Wagner Act, the pillar of the New Deal that guaranteed the right to collective bargaining.
And that ruling wasn't just about labor unions. It was a massive expansion of the federal government's power under the Commerce Clause.
Precisely. Historically, the court had very narrowly defined interstate commerce, which restricted Congress's ability to regulate things like manufacturing or mining. By upholding the Wagner Act, the court was now saying that even local actions, like a labor dispute in a single factory, could have a substantial effect on interstate commerce.
Which means Congress can regulate it. Yeah.
This 1937 shift, the end of Lochner and the expansion of the Commerce Clause, that is the constitutional revolution.
So while the court is undergoing this transformative internal change, what's happening to Roosevelt's court packing plan? The thing that was supposed to force this change.
It collapsed.
Period.
Completely. The political momentum just evaporated after Roberts' vote was made public on March 29th.
Mm-hmm.
I mean, why would Congress fundamentally restructure the judiciary if the judiciary had suddenly shown it was willing to approve the New Deal? The justification was gone.
And the decline of the bill was sped up by 2 final events.
The first was the retirement of one of the conservative four horsemen. On May 18, 1937, Justice Willis Vandevanter announced he was stepping down.
Which was critical, because that gave FDR his first actual appointment to the court.
He could now change the court's balance the traditional, legitimate, constitutional way. The urgency for the court packing plan vanished.
And by July, it was officially dead.
July 22, 1937. The Senate voted to send the bill back to the Judiciary Committee, which in legislative terms is the final, definitive way to kill a bill without a messy floor vote. The whole firestorm just ended with a whimper in a committee room.
But the political drama of that period, from February to July of 37, it was so intense and so quickly resolved that it immediately became part of American political lore.
It did. The entire sequence was summarized perfectly by the popular humorist Cal Tinney. He coined that enduring quip.
The switch in time that saved 9.
Exactly. And the phrase stuck because it captured the immediate political narrative, that Roberts had been spooked by FDR's threat and switched his vote just in time to save the 9-justice structure of the court.
But as we've established, based on the memos from Roberts and Hughes, we know the timing in that popular narrative is a little off. The vote was cast before the plan was announced.
It was. But the sentiment is absolutely correct. Roberts' willingness to change his mind, and for that change to become public when it did, It instantly defanged the president's plan and preserved the court's institutional integrity.
So the victory here is complex. FDR loses the battle over the bill, and it was a major political setback that strained his relationship with Congress for years.
He lost the battle, but Roberts' switch allowed him to win the war over the law.
That's the core takeaway.
I think so. Roberts saved the court from political restructuring. And by doing that, he allowed the judiciary to begin approving the vast array of economic regulations that define our modern government. Social Security, collective bargaining rights, consumer protections, the minimum wage, all of these underlying structures of the modern American state flowed from that one quiet decision.
The historian William Lechtenberg argued that even though the plan failed politically, it was a crucial catalyst. That the threat, combined with the reality of the Depression, forced the hand of justices who were already grappling with the failure of their old jurisprudence.
The political environment became so toxic that the court had no choice but to shift its philosophy toward deference, recognizing that the legislative branch was better positioned to respond to the economic reality of the 1930s.
And that brings us full circle to our conclusion, the fragility thesis. We've spent this entire deep dive focused not on sweeping, inevitable forces of history, but on the decision of one man in one room.
Which forces us to ask that core question again. Is the stability of our constitutional government built on immutable principles? Or is it built on the private conscience and the internal evolution of individuals under extraordinary pressure?
The Roberts decision seems to argue for the latter.
Overwhelmingly. We tend to look at institutions like the Supreme Court, with its marble columns and its traditions, as these permanent anchors. But in the winter of 1936, that anchor was one vote, one change of conviction, away from being dragged into a political storm from which it might never have recovered its legitimacy.
Let's just revisit that catastrophic potential one last time. If Roberts had simply stuck to the precedent he set just 1 year earlier in Moorhead, the West Coast Hotel decision goes 5-4 against the government.
And that ruling would have provided the president with undeniable popular and moral justification for his court-packing plan. The bill likely passes, the court expands, its decisions are immediately flipped.
But the cost would have been devastating. Future presidents, seeing a political roadmap, would have been tempted to alter the court's membership whenever they faced judicial resistance.
Roberts' silent act of, call it legal honesty or political pragmatism, it saved the court from being exposed as just another political tool. He preserved the idea of 9 independent justices.
He demonstrated that the court could bend on policy so it didn't have to break as an institution.
And that act of deference preserved the checks and balances, and it maintained the court's stature in a way that you could argue continues to benefit its institutional longevity today.
It's truly stunning to think that such an immense constitutional balance pivoted on an invisible hinge, a decision made in secret months before anyone even knew the war was over.
It reminds us that governance and reality are far more fragile than we tend to imagine. History isn't just shaped by grand inevitable forces. It's shaped by these quiet human moments, by tiny shifts in conviction that ripple outward to create the world we all live in.
Which leaves us with the final provocative thought. We were constantly focused on the public, noisy fights in Washington, the bills that pass, the statements that are made. But what other invisible hinges, these private, unrecorded decisions being made by key individuals in positions of power right now, shielded by institutional secrecy, what other hinges might our entire world be turning on?
A profound point to consider. We are all living in the world that was built from that one quiet vote in December 1936. Thank you for joining us on this deep dive.
We'll see you next time as we continue to explore the seconds that change history.